Welcome to the fourth mock civil mediation. Today we have a rather large cast. I'm not going to introduce each one of them, but I'm just going to go over some of the procedures for today. There are going to be two role plays, and they will be both done one after the other, and then there will be questioning time. You can enter your question as you go along in the Q&A. Please don't also enter it in the chat. And also at the end, you'll be able to raise your hand and ask questions then. So with that very brief introduction, Lucille, it is now yours.
Thank you. Good afternoon, everyone. Welcome to the role play of Stardom. I want to introduce to you quickly who we have with us today. We have Jenny Puchta, who will be playing the plaintiff. We have Lenny Solandz, who will be playing the defense in part. We have Risa Wasserman, who will be plaintiff's attorney, Andrew Smith, who will be the defense attorney. Lenny, who is new to the mediation field and has been doing all his due diligence, is working hard in getting various accreditations. Jenny, myself, Risa, and Andrew are accredited professional mediators. With that, we will begin our first role play. I am Lucille Alfano, the mediator. The role play for number one is one of a law against discrimination, sexual harassment / termination case. Jenny A.J. Gorey is the plaintiff who has been terminated and has filed a claim against the International Butcher Shop owned by the butcher, Lenny, that you see here. Risa Wasserman is Jenny's attorney. Andrew Smith is Lenny's, the butcher, attorney. The case before us has been before me for 3 separate mediation sessions. The allegations are some of which sexual harassment, physical touching, asking Jenny by the supervisor of the butcher shop, which Lenny owns. The butcher who is here today is the owner of the butcher shop. The supervisor is the person who has touched Jenny in various times, who have asked Jenny to go into the butcher shop freezer department there to get warmed up, who has constantly texted Jenny, who has emailed Jenny to assist her with her daughter, who has been home remotely during the entire COVID time. Jenny has filed these allegations whereby she has had to stay home with her daughter and has had difficulty returning to work under these kinds of conditions. After going through several types of proceedings in front of me, we have had different positioning. The plaintiff and her attorney have been kept in separate rooms entirely. The defense, the butcher representing the supervisor, has been kept in a separate breakout room entirely with his attorney. We have finally come to an agreement to settle the matter. And the agreement is so we can resolve it and actually dismiss the case. I'm going to ask everybody to please read the settlement agreement. What we are going to do in this particular role play is bring the parties together and making sure that each party has reviewed this agreement beforehand, has consented to this verbally beforehand. The most important thing to do is to now have them sign the agreement so it becomes an official document. What I'm going to do is take each person, the plaintiff and her attorney, the defendant, and the butcher who is representing the butcher shop out of their breakout rooms and put them in the main conference room. Okay. We now have everyone in the same conference room, and I am going to ask them. Plaintiff attorney, Ms. Wasserman, have you reviewed this settlement agreement with your plaintiff?
Yes, I am. And now there's a problem with it.
Well, let's wait a minute.
Yes,
Andrew?
I have read it. Yes.
Andrew, Mr. Smith, have you read
Yes,
this with the butcher?
yes, we've read the agreement and it looks acceptable to our side. So I think we're ready to sign and move forward with this particular situation.
Okay, great. With that, here's what I typically do, everyone. Out of respect for the 3 days of mediations that we have had, we need to have this signed. I will not end this mediation, close it out until this gets signed, given to each other, you know, acknowledge that it's approved. I will end my time at this point. We have done 3 days of mediation. I will charge the parties 11 hours cumulative and say I am so pleased that we've worked together as well as we have to solve a very hard situation during the COVID pandemic. At this point, I will close out my time as a mediator. I will bring in my co-mediator and wish everyone well. I'm looking for our my co-mediator. Terry? I'm waiting for Terry.
I'm
Come on
sorry,
in,
we got
Terry.
disconnected.
That's okay. Are you connected?
I'm connected now.
Can we see you?
Yes, you can.
Okay, there you are. Everyone, this is my co-mediator. I will conclude my fee for this case. And Terry, all we need for you to do now is get the matter signed and we will be done. Okay?
Thank you, Lucille. Hello, everyone. Lucille updated me on everything going on here. And I understand that she has a settlement agreement that she would like signed. She would like to see all of you signed, that you've all put in a great amount of work here. First of all, I'd like to move forward and make sure that we're all in agreement with this document. The plaintiff side, please.
I'm not comfortable at all with signing this document as it is, because I think something is missing from this document. The mediator fees should be paid by, by my old employer. I think he should be responsible for paying my the mediator fees, because I wouldn't be doing this. I wouldn't be in this situation if it wasn't for what happened to me.
Wait a second. Wait a second.
Hold on,
agree.
please. Hold on. We'll speak one at a time, please. I'll give everybody a chance to listen.
May I speak on behalf of my client since you spoke already?
Sure, this, yeah, I'm very concerned what I'm hearing. So it looks like the agreement should be signed. We're ready to sign this thing and
All
just
right.
move the ball forward. So what's going on here?
I can't
My
sign
client
it.
is
No,
not ready
hold
to
on,
sign.
please. Hold on.
We already agreed.
This
that we're
was
paying
already agreed
$10,000.
before we started the program that everybody would have an opportunity to speak. No one speaks over one another and everyone gets a chance to be heard. So first, let's finish off with the plaintiffs here and then Mr. Butcher, I will come back to you. Ms. Wasserman?
Thank you, Ms. Terry. My client cannot agree to this. First of all, we had discussed a possibility of defense counsel paying all the mediator fees, and this is not what we were discussing. And I'm not sure how it ended up this way, but we did not discuss it. She has added costs. She had to get a babysitter the entire time to stay with her child while she was on the mediation Zooms, and she's had many more expenses than she expected. She's been terminated. She has no other job at this point. She has not been hired anywhere. The damages are continuing, and I'm really sorry, but we can't sign.
That is all
All right.
baked into the number that we have, this 95,000. So everything that plaintiff attorney is saying has already been baked into this situation. My concern is that we have gone 9 full innings, if I could use this analogy. The game is over. We're ready to sign this agreement and be done with this case. We do not want to open up this case again. I mean, nothing has been proven. This is just alleged. And as I go to try to solve this case today.
Andrew, remind them that we're paying $10,000 of their legal costs too.
There you go. There you go.
It
So we're ready to
is
sign, and we hope
proven.
the other side
Ms.
is ready.
Gorey, please let Mr. Smith finish speaking and I'll give you your opportunity.
Folks, as the
Smith?
other mediator has just said, we went through 3 days and there was an opportunity to say anything. We all have come to a conclusion. We are ready to sign. Everything is baked into this agreement. Everything has been taken into consideration. And most importantly, it's only alleged. Of course, we empathize with what your person is saying. We empathize with her, but this is only alleged, and we're ready to move this agreement forward.
True. It's not alleged, it's true.
All right. Ms. Gorey, obviously these statements were made during these last 3 days of mediation. Would either you or your lawyer please address that, how you do not see this point of payment being addressed during these last 3 days?
It has not been addressed, and we had suggested it many times in the last mediation, and I don't know how it did not get taken care of, but we are not signing today. And so, Ms. Mediator, I need you to come up with a resolution of how we're going to go forward.
I can propose a resolution. We can decrease to $95,000. That's one way of doing it. That's what I see happening. We can decrease to $95,000, keep the overall pot the same. But if we are looking at going beyond $95,000 plus the $10,000 my guy has already paid, I don't see how this deal is going to be finished today. I really don't.
Andrew,
Wait,
tell her.
Mr. Smith, you mentioned less than $95,000. What is your proposal to come down to this if this is what you're proposing?
That's not going to work. I have babysitter fees. I'm not working. I have no money. I've had to borrow all over the place. I had to go to the food bank. This is not going to work. To take off extra money, that's not going to work for me. It's not going to work at all.
Take it out of the attorney fees.
It's not going to work for me.
All right. I'm sorry, I can't see everyone on my screen here, so I'm going back and forth. Ms. Wasserman, what was originally proposed on your side for Ms. Gorey in this set?
We had discussed at the last mediation that they would consider paying the entire attorney fees at mediation, the mediator attorney fees, and whatever the hours turned out to be, that they would cover it. And now they've done something different here in this agreement.
I apologize for this misunderstanding, but I don't recall that conversation. Apologize, but I wasn't part of that conversation. Perhaps you and the mediator had that conversation, but it wasn't with us. It wasn't with the defendant or defendant's counsel. So apologize, but that's not my
So,
concern.
Mr. Smith, now can you please speak to your client about whether they could come up with the money? You know she's been wrongfully terminated and suffered sexual harassment. Could you please speak to your client now and see if you can come up
I
with
spoke
something?
with my client at length. Just to get the 95,000 on the table has been a major challenge. I mean, the guy office, his business has been closed because of the pandemic. He is struggling. Both sides are struggling, but he can't even keep his business open. He's just running orders here and there. People cannot come in because of the pandemic. He is in a very challenging situation. He is really struggling just to pay the 95,000.
This could
I
bankrupt me.
respect
All
that,
right.
but
Go out of business here.
All
I'm
right.
struggling to
I'd like
make
everyone
right.
to just, I'm going to put you in a caucus room. I need a few minutes to speak with Ms. Alfonso about this case so I can have some background and we can fairly deal with these issues and close this out for all of you today. This seems like it's been weighing very heavily on all of you, and to prolong the signing without all of us being on the same page is just going to prolong the anger and the frustration for all of you. Can you all hold on, please? I will be back with you shortly.
Okay,
Ms.
everybody. Thank you. Thank you, Terry. Thank you. Thank you. We want to have a little bit of time with the audience. And of course, these are the actors. That's the butcher and the plaintiff and Risa and Andrew. But please, everyone know, Terry had no knowledge of what she was stepping into. And the reason for that is because this is a deal breaker. This one has happened to every one of us presenting today. It has happened both virtually and it has happened in person. The purpose of our mediation role play today is to have somebody come in when you don't know what's going to happen. Terry was not part of this. Terry had no idea. Because that's what happens in a mediation, everybody. You never know what is going to blow up. Now, we, the stars here, and including Terry, we'd like to speak to you about what happened with us and how we had to handle it. Now, in order to have this particular case brought before you, we had to do it in the sense that we had to have a group meeting signing the document. I, as a civil labor mediator in a sexual harassment termination case, would not have the parties together to sign such a document. It's a horrific type of case. In cases of this sort, I keep them in caucus rooms or separate conference rooms in real life, in-person meetings, and would have each group sign and then, of course, copy them. However, this is not just the only deal breaker. There are several types of deal breakers. And once you have people together coming down to the end and they refuse to do that, what Terry said was the best thing ever. Separate them. That is my way of handling something. Now I'd like to turn to our panelists to let you hear how they've handled something. Andrew?
What I would normally do is make sure the parties understand how the bill is going to be split. If it's going to be the defendant side, that may be a company or corporation, if that's agreeable. At times, there are situations where I see the dynamics of the process changing based on the numbers. One of the sides may, in the middle of the mediation, ask me, I see us reaching a settlement, but would you be okay if I talk with the other side about paying your fees, and I'm open to that. But it's a rarity that a situation would come to this level at the end of the day without the parties being on the same page. So I always try to monitor that process going through the entire mediation skill set, if you will.
Risa,
I actually discuss who's paying the fees as early sometimes as a conference call at the very beginning of the case. If it's parties that are where the equities are not balanced, like Andrew says, where one party has lost their job and the other is a corporation, I might discuss it earlier. I've often had the plaintiff's attorney ask me early in the process, either by email or otherwise by phone. They often ask me who is paying the fees. So that's one factor that I agree with Andrew on. You usually do know that. But I agree, they would have to be, Terry did a great job separating them at that point when we got out of control and she couldn't really deal with us. She did a great job knowing she had to separate us. And unfortunately, I think there might have to be a conference call in this case or another discussion, possibly in person in separate rooms to resolve it.
Lenny,
I have made sure that, as Risa said in the pre-mediation conference call, that I've expressly stated what the fees are and how they get paid. And I also, at the beginning of the mediation, state exactly what the fees are to the mediator, and it is a cost borne by both parties unless discussed otherwise during the settlement. But you have to make it upfront and direct. You can't be bashful about stating what your fees are.
okay, Jen?
And one situation, many situations can happen where you have more than two parties or two defendants. And I've had cases where you can have family members and deciding how something is going to get split, or if you have two sets of defendants, but one of the defendants has two partners and they originally were three partners, how something would get split. So in that case, they made the determination to split it 1/3, 1/3, 1/3, even though there was really two separate entities, but that was their choice. And we, brought that out towards the end of the agreement, but that seemed to help. So, and we can't really assume. I think it's something, as we're all stating, that, we should really talk to the parties and how they see the mediation fees getting paid.
Well, Terry did a great job. The big thing was that Terry was separate the parties. Bringing people together is important if they are ready to face each other. Now, in this case particularly, Lenny the butcher was not the supervisor where the allegations were, which typically would be in this manner. The person being alleged as the person saying all these things to the plaintiff usually doesn't show up, and it is the employer. But the employer has an obligation to cover himself or herself. So it's difficult at times, especially in very emotional settings, to bring people together if, in fact, it's a very sensitive issue. Keeping them separated allows things to flow a little better. Anyone else have another comment? Terry, do you?
It was hard coming in cold, and I wanted to make sure, and I think Jenny, you had one of the first cases I did in our court cases. You want to be careful to hear, but you want to be careful. Jenny was very good at bringing this forward for me. You don't want it to get so far that you can't have a discussion anymore.
Good. But the most important thing you just said was coming in cold. And what we are doing today is working through a process, and then boom, something happens. Because that's what happens in mediation. You're not prepared for it. We knew, but Terry didn't. In real life, I've done the mediations, and these different situations have happened. We didn't prepare for it. They happen. What is it that you do when that happens? You have to be ready to handle anything that comes before you.
Yeah.
And that is what we want to make sure you understand. And Terry was just what each one of us were when things happen. Jenny?
And at this point, we're talking about deal breakers, not necessarily just leaving it to mediation fees. So as
Correct.
panelists, just addressed mediation fees, but what do we do if something else unexpected happens that is a deal breaker? And it is to, I would do what Terry is suggesting too, and what Lucille has suggested, put to separate the parties, and then just say, really try to find out more. Please help me understand. Using those words, please help me understand. I thought this was, resolved, but please, help me, understand, and then be transparent and deal with what has occurred.
Okay.
And in this case,
Lucia?
I wanted to,
I have a question. What were the mediator fees? What was the amount?
11 hours, so we're talking several $1,000s.
Several $1,000s. So I have a question about that. I mean, if you have a mediator fee of $3,000, $4,000, $5,000, what? Pick an amount.
$5,000.
$5,000. Is it really sensible for the parties to blow something up over $5,000? I mean, really, the difference to the butcher is $2,500. When you think about it in terms of $2,500, is someone going to walk away from that? I'm wondering if that's something that should have really been pushed out for it.
And Carl, that's key, because what this process involves, as Lucille said, things can blow up, and it's those little molehills that trips you up, not those big mountains. People get so involved, so emotional, they may not see the easy way out. And so therefore the mediator has to keep that overall perspective, to keep the parties aligned, to keep the parties understanding the big picture, which is very critical, as you just indicated.
Okay.
Yes, Terry.
there are two things here too. One, I'm a new person coming in. I want to make sure that the clients don't feel that I'm going to spend time for them and prolong the case beyond the time that's already there. The second thing is you have to be very aware of the fact that when a new person comes in, a party or parties can take advantage of that and start to feel that they can start the clock running again. You want to make sure that you're picking up the ball and running, not reinventing the whole case.
Which is true, because I did say that we would stop at 11 hours. If this had to progress, which it has in some areas, then they're talking about additional fees. But this is, like Jenny said, we did it as a mediator fee situation because it has happened to all of us. We are speaking from our own experiences, but there are several other issues that create deal breakers, and the whole sense of learning to be a mediator is to sense it, see it, and do everything you can to get it under control so that you can progress forward. I have to thank everybody, especially you, Terry, for stepping up to the plate and
My pleasure.
because we are going to begin our second role play with our second participant who knows nothing about what it is. Thank you,
Thanks,
Terry.
everyone.
Okay.
Thank you.
Thank you, Terry.
Okay. Let's get ourselves set up for second role play. Lenny?
Okay, bear with me.
Mm-hmm. Bye, Terry. Okay. Okay. All right. I think we need to get Terry off. Carl, I don't know how you do that. That's it. Okay. Well, I hope you enjoyed our first little scenario. Our second scenario is one whereby we are now going to do the opposite part of the mediation. We are going to be doing the beginning of the mediation. As such, in in-person mediations and as such in virtual mediations, only the participants and their representatives and/or people of necessity that the parties are aware of can participate in the mediation. As part of the virtual mediations, this is an agreement I send out. I'm going to ask everyone to please read it. Make it larger. Can you make it a little larger? There you go. Okay. Okay, and those that have signed it. Okay, thank you. Good afternoon, everybody. I am Lucille Alfano, the mediator. I am an accredited professional mediator. I am a labor arbitrator. Contracts are of my expertise. This matter before me this morning is one of a construction matter, breach of contract. Jenny, our homeowner, Ms. Wasserman, you are plaintiff's counsel. Mr. Smith, you are representing the general contractor. As I understand, the general contractor will not be joining us today. Is that correct?
That is correct.
Okay, you did sign that agreement. I'm going to also say that everyone here, especially you, Mr. Smith, has authority to settle this matter on behalf of your general contractor. Correct?
Yes, correct.
Okay, fine. The matter, as I have reviewed it, is one of breach of contract, as I said. We had allegations of several types of deficiencies. I also understand, Mr. Smith, from you that you are looking for third-party defendants. You will be filing for third-party defendants. Okay.
That is, yes.
Okay. The third-party defendants are not named, and nor are they part of this particular mediation at this time. We are, at this point, Mr. Smith, if in fact you need to recover from them, that your litigation separately and apart from us. We are going to be reviewing all of the allegations, and any questions. Your documents should all be exchanged. I know that I have all the contracts and invoices and change orders and failure to and those change orders that were not effectuated. All right, saying all that, unless you have any questions, anyone have any questions on the process? No, thank you. Okay, I'm going to start with opening statements. Ms. Wasserman, you have any omitting statements on behalf of the plaintiff?
Yes, I'd like to make a short one. I represent Miss Jenny, who was building a beautiful beach house in New Jersey. And this defendant contractor agreed to do all the work on the house. It was paid a small fortune of $2 million under the contract. He did defective work, and now what we have is skylights, windows leaking, damages all over, trim that's been damaged, floors that are damaged. Basically, we're alleging breach of contract and defective work. We have all the change orders. Miss Jenny advised him of all of the problems as they were happening. Nothing was properly repaired. She has estimates from other contractors. She has work that's had to be done by other contractors. She has been damaged tremendously financially, and we have all the estimates and proofs of repairs to prove it. The defendant has $5 million of insurance, and we've seen that policy. And we are suing for substantial recovery for all the damages she suffered. She's unable to live in the house. She cannot use the house. And she is here to advise the mediator of all the damages we've suffered and what the costs have been.
Okay, I'll speak with Jenny when that's necessary. Right now, I have all your documents. Mr. Smith.
Thank you for the opportunity to speak. I am very concerned with some of the comments I heard by opposing, well, I shouldn't use the word opposing counsel, but since we're in this session for a brief time, hopefully we can get this settled. But I am concerned with a lot of her comments because on what we understand is that there were a lot of change orders at the request of the homeowner. She wants this change, that change, that change. So she did not adhere to the contract as originally contracted. Definitely, she's allowed to make change orders and requests, and we fulfill those change order requests. However, we believe we caught everything that she wanted done. She made this change, she made this change, and Miss Jenny, the homeowner, what we see as the changes are very minor. And so the Miss Jenny, the homeowner, I think she's very elaborate in her comments, and her attorney is just really blowing this all out of the water. I am, as you said earlier, we are planning to have third parties involved in this matter, subcontractors, just to make sure we dot the I's and cross the T's. But from what I can tell, in talking to my team and talking to my side, that there were minor damages, very minor. And so I am very concerned when plaintiff counsel mentioned massive damages that took place. This is not our position. And so I'm very concerned that they simply are just positioning for a higher amount because the changes were done according to the homeowner, Miss Jenny's request. It appears that we've dotted the I's and crossed the T's, but as I mentioned earlier, as you know, we are looking to bring in subcontractors so we can clear these minor situations up. And so that's our goal. In fact, I'm glad you're here, man.
Andrew, just remind her that
What is going on here?
Thank you, thank you.
What? Who's this? Excuse me, mediator.
There's no problem.
Mediator, this person, I don't know who this is. They're not authorized to be here.
Wait a minute. Excuse me.
Whoa. Before I make one statement, everyone will remain silent, and I'm bringing in my co-mediator. Glenn, you just sit there. Glenn, it's all yours.
Okay.
This is the guy who destroyed my house. He destroyed everything. He's the one who caused the
Whoa,
Wait,
slow down, please.
Pictures have been taken.
Well, slow down a moment. I was just brought into the room. I do not know who the parties are. I do not know what's going on. You're yelling at each other. That's not going to get us anywhere. So let's start at the beginning. Let me first find out who is present in the room today.
I'm plaintiff's counsel, Risa.
And I'm defendant's counsel, Andrew Smith.
And I'm Jenny. I'm the homeowner.
And I have Lenny. He's one of my, well, he's one of the subs, and he's very critical to this case to get this case resolved. And I know plaintiff want to get this case resolved today.
I
Mr.
understand that.
Mediator, this other party has not
I
has not been
understand that,
served and is
however,
not in this
She's
action.
supposed to have Anderson windows. She brought in Pella windows, different size openings. If there's any.
Excuse me, Mr. Smith, I'm going to ask you to, first we got to decide who is properly in the room. My understanding is you were not invited to the mediation. You are not a party to the mediation. And it's also my understanding that at this particular point, your discussions or whatever should be represented by your counsel. And my understanding is Andrew
you're
Smith is
exactly
not your
correct.
counsel.
You're exactly correct. That's why he's here, because I have, as was indicated, I have full authority to settle this case. So I'd like him to be here so we can help settle this case today. I know plaintiff counsel and the homeowner would like to settle this case today, and that's why he's here.
So Mr. Smith was here by your invitation, is that correct?
I was invited by Mr. Smith.
And it's my understanding that he appeared somewhat time in the middle of the discussion with people not knowing he was on the line.
That's correct.
And I think that's the issue that we need to address right now.
I was
Thank
invited.
you,
There was an
Mr.
agreement.
Mediator.
There was
What
an
are you talking
agreement that
about? I
was
asked to come
signed
here. I
that
didn't have
said
any
that this
agreement.
meeting would not be held surreptitiously. There would be no recordings. There would be no other people in the room without their identification.
I had no agreement.
That is correct.
But he can be in the room. We want to resolve this case today.
I
mean, it can
understand you
save
would like to
time. It can save
resolve
money for all the parties.
I
He's
understand
very
you'd like to
important.
resolve
He
this
can
case
describe exactly
today.
what's going on. He
Mr.
can
Smith.
describe the work, what actually took place. He can describe the damages, the change in the windows from Pella
Attorney
to Anderson.
Smith, at this
Yes.
particular point, I'm going to put you and the other Mr. Smith into a separate room, caucus room, and we will discuss what it is you need to know from him. This is not part of the discussion that needs to be addressed by Jenny and her attorney.
Mr. Mediator,
and
I
her
object to
attorney-
that. I object to this guy staying. He should not be talking to a person who's not his attorney and who he has not been part of this case. And if Mr. Smith wants to bring him into the case, he can deal with the court with that. But right now, Mr. Contractor has enough insurance to resolve this case. And this guy doesn't belong here at all in caucus room, in discussion, or even discussing it with you. He is not part of the damages, and he is not sued right now, and he's not served. And the court is assuming that plaintiff and general contractor are having a mediation now. And all those rules that we have put together for virtual and non-virtual mediation are being violated right now as this guy comes in who we know nothing about.
We understand the rules. Again, I have full authority. Again, we want this case to be settled today. I know the homeowner wants her house taken care of. This guy, the subcontractor, he's very key. He can help resolve the issues.
He's not to be trusted.
Mr.
He's
Smith,
not to be trusted.
At this particular
Windows. They were
point-
your windows, not my
No,
windows.
At this particular point-
Everything else. No.
Nobody's gonna
I was
speak up.
invited in. I got an email with a link. I joined the link. Mr. Smith.
Nobody is going to speak over me. And quite frankly, as the mediator, I'm going to shortly dismiss the Mr. Smith who came in surreptitiously from the meeting altogether and block his appearance unless the Attorney Smith is willing to accept him into a caucus room. And if you want to split off and speak with him, I'll give you a few minutes to do so. But what you're trying to do here is improper discovery. It's improper procedure. It is not what the parties agreed to, and it is not going to facilitate a mediated settlement today.
I have no problem with bringing my guy into caucus because he's very key. He's very important to us resolving this case.
Did you
And
have
if
a
he's not
chance?
here,
Did
if
you
he's
have
not
a
here,
chance to speak to Mr. Smith separately from today?
I sent him a
Get out
link.
of the-
You know what
get out of
sent him a link.
this room.
Do you know what issues he's trying to raise here?
There
Or
are
will be
many
raising?
issues. He's one of the key subcontractors. He understands the
he's
issues
one of
with
the
the
key-
windows. He understands the leaks that she is alleging. And
Mr.
these
Smith,
things were
I am
because of
not
change orders
going-
that she initiated.
Mr. Smith, I am not going to interrupt this mediation for you to give evidence or supply evidence or talk to your witness or gather information that you may or may not have had in order to resolve the mediation. Right now, the mediation is between you and the plaintiff, and the discussion that needs to be had amongst the parties to the action. Everybody else, as far as I'm concerned, is superfluous at this time. If you want to bring him into the action and we have to reschedule the mediation, we could do so. However, that'd be nothing but a delay in time, and you're not going to get your wish of resolving it today.
And
If you
Mr.
really
Mediator,
want to
it sounds
resolve
like
it
we're on the same
today,
page. It sounds like we're on the same page that it's a potential to get this resolved today if the other side would just open their eyes. And of course, I don't want to be offensive, but all parties should want to get this thing resolved today. That's the
it's
goal
not
of
for
mediation.
them to, it's right now, all the other Mr. Smith is going to do is bring in information about things that are not on the table right now. On the table right now, we're talking about the damages and we're talking about potential settlement. We're not talking about how we got there, why we got there, what issue belongs to this particular subcontractor as opposed to another subcontractor, and all the other information that's involved. What we need to do here is to work out our procedures for mediation pursuant to the complaint that's before me. And when
understand
I
what
say
you're
complaint
saying.
before me, you have to understand, I'm just a mediator here. I am not an arbitrator. I am not a decision maker. That's up to the court. But I'm here to work out a unified settlement table. In other words, where people can actually discuss and talk about the issues with each other in a way that they see fit. And right now, the plaintiff does not see fit having this individual in the room, or even having this individual participate, or even speaking to you for that matter.
I even object, Mr. Mediator, to him listening to this discourse. I believe we need to get him out right now, virtually, so that we can decide how we're going forward. I don't even want him hearing all of the details from my client's damages. Right now,
Look, I am
he's not-
concerned.
Okay,
I am
everybody.
Oh, I will
concerned.
not go further with
These
discussion with him in the
damages-
room.
I
These
belong
damages
here.
are
Ah!
alleged. These damages are alleged. Oh, go ahead.
No, Dominic, you're not Dominic. We did this. Glenn, you were great. We have to stop because of time. And
Okay.
again, everyone, Glenn did not know anything, just like Terry did not know anything. And with all of us, the surprise person and in person, all of a sudden shows up, and also virtually. And if anyone took note, how Lenny came in as Andrew was exactly how someone came in to one of my virtuals, whereby they never received anything from me and they linked off of another person, which means no matter which way you do it, it can happen. And it did happen. It happened to all of us. Again, what do you do when the person who is not part of anything shows up? And that, again, is a very, very important situation because of how the mediation is going to go forward and who's permitted in and who's not permitted in.
Lucille, if I may, I know when I
Sure.
do my mediations, first thing I do is I set up waiting rooms. And once everybody's in attendance, I lock the rooms so nobody else can enter.
Glenn, let's let Lenny explain this because this happened exactly to me. I only have waiting rooms in a virtual setting, okay? Only. And the person popped in, just like Lenny. I had to ask Lenny, how did that happen? Lenny, explain it, please.
What you may not realize, when you receive your link from Zoom, it's a unique identifier associated with your email. So if you forward your link to someone else, they will appear with your name.
Yeah.
So you could actually have 4 of yourselves if you forwarded it to different parties. It's important to ask for everyone's specific email who will be participating. Otherwise, you're going to see multiple renditions of your name. So Glenn, if you sent me yours and I logged into this conference, you would see your name appear twice.
Yeah.
So it's very
And that's how it
important to
happens
be clear
virtually. Yeah.
that you have the email address for each participant and you do not forward to any third parties your link.
And because, Lenny, I don't want to say it incorrectly, but because Andrew is already in by virtue of the waiting room, he has been admitted in. Once that happens, the other person coming under his link just bypasses the waiting room. And now we know. So that happens, everybody. That happens. It happened to me. It has happened to others. And how do you handle it in a virtual setting? Jenny?
I had a situation where, we did have a large group and somebody did not use their name on the screen. So they came in with like a crazy name, like a nickname that nobody would know who it is. And I was saying, who is this? Is this anybody, is this the party or who is this? That person would not identify themselves. I kicked them right out. Later to find out it was the plaintiff. And then we had to reset everything up immediately afterwards, but she didn't, she did not respond, but I'm there to protect, I'm there to protect the process, and I kicked them out. And then, we started 15 minutes later to have her, to have everybody sign in again, with a new Zoom meeting. So it's just something to maybe let everybody know to have their proper name show up on, on the screen as an identifier.
I agree with everything that's been said, and I wholeheartedly to that. But it does bring I guess, a slight tension when you see that this party that wants to come in has very valuable information that can help resolve the issue, which is what everybody wants to do. So that's where the balancing act. You can't let them in. So the question on the floor: do you reschedule the session? I'm just curious to see how people would generally want to handle that. And Lucille, I know you're very strong at that, so perhaps you should start first.
Depending on the parties, who they are, and the tone of the mediation, okay? I have done in-person mediations where all of a sudden defense comes in and says, look, I have the insurance person with me, representing the insurance company. We say to the plaintiff, look, the insurance people are here. Is that okay? And lots of times that has been okay, and I make it very clear, you should have gotten permission first so that they understand this is not permissible. We have to know who will be attending. If everyone agrees that that is someone and the person apologizes and it's not an adversarial type of thing, we go forward. But one thing I will not allow is for someone else to control the process. And I make that very clear from the beginning. You have anyone that you feel is important to this process and is not a named party and is not the named attorney, you get permission first. That comes through me. Because otherwise they'll be tracking in everybody and anything. And I make that very clear because everybody has to be comfortable to whom they're speaking with, because this is the only time you have a confidential type of a situation where people can brainstorm ideas. And I'm very, very serious to take this one step further about having plaintiff, Jenny, and Risa, her attorney, be in separate buildings. Because if Risa, Andrew, and I want to sit down and brainstorm, we want Risa to be comfortable saying some ideas that she could never say in front of plaintiff, just to brainstorm. So that takes this one step further. You have to be careful, not only who's in the mediation, but where they are. Because in virtual, you don't have the opportunity to pull people out of a room, go into a separate room down the hall, go into another, coffee room by yourselves. You don't have that opportunity. So you have to be very, very careful of what you're saying that someone else can hear. Because especially as attorneys, folks, your client can turn around and say, what did you do to me? So everybody has to watch that very, very carefully. But in person, they're not permitted to bring anyone else in unless they've gotten the permission. Should it happen the same way which was occurring here with Glenn and with Andrew? If it's someone that's going to help, then let's take a look at it. But if it's someone that has created the adversary, doesn't work. Carl.
We only have a few minutes left. I don't know if you want to open it up to questions, but I have.
Well, go ahead, because our panelists want to speak to it. Go ahead.
Okay. Question is, if it were decided that this person should be able to attend the meeting, would you require them to sign the agreement to mediate before you let the person participate?
Would I, Lucille? Absolutely is right.
Okay.
You know that, Glenn. Absolutely. Because that's a confidentiality agreement regarding recordings and everything else that you typically don't have those problems when you're in a law office in a conference room.
Well,
unless
I
you're
also
sitting
have,
in. Yeah.
I also have interpreters sign. I also have people who are there just to give moral comfort to an individual. Whoever's sitting in that room has to sign that confidentiality agreement.
Sure. Because if they ever put something on YouTube, on Facebook, then, you don't know what these people are doing all off on their own.
Okay. So as I understand the way you would approach it, Lucille, is you would first try to find out whether this person is going to be valuable to the mediation and whether you could get the other party to agree to it before just saying, this is procedurally wrong, you got to get out.
No, I've done that, Carl.
You've done what?
Who are you? You don't belong here. You're gone.
Okay.
No,
Without
I've
even-
done that.
Okay.
I've done that because you could see, even while we're staring at a screen like this and people are looking at us, I could see the other party, all of a sudden their eyes go like this. Okay. Who is this person? Just like Jenny Risa, who is this person? You can't allow that to fester because that is your biggest deal breaker. Okay. Keep it so that this is how we all agreed to do it. And I'm showing you, I'm keeping that agreement. Okay. And it's happened to me both virtually and in person where people have popped in. So, and Andrew, it's happened to, Risa, it's happened to all of us. Depending on who the people are is a big factor. But you see those eyes go up, you take control right away. And yes, the most recent one that happened virtually to me, the person went right out. And when the other attorney began to say, I want to know who that is, I was able to say immediately, it's done. It's over. The person is not here. And it stopped it. So, again, depending on the cases you do is a big factor. All right. And we have to realize the cases and the participants all make up how your tenure on the issue is going to be. Carl, I know we're running very late now, aren't we? Yes. I hope everybody enjoyed us. And thank you, Glenn, for stepping in.
Yes, thank
Try
you.
my best.
I want to thank you too. It was really very, very good. You put people, the guest mediators, in a difficult position stepping in like that, but they really did a very nice job.
But
So,
it's real.
Yes, it
They
is.
knew
briefing.
nothing because when you're in a mediation and you're the mediator, you don't know it's going to happen. So it has to be real. I appreciate Glenn and Jerry's. Boom.
Okay. Well, thank you very much. Let's see, next week, as far as webinars, we have Tech Time with Lawrence and Carl next Monday. A week after that, we're going to have a webinar on college education funding, loans, those kinds of things. And the last week of the, no, it says the fourth Monday, we're having a mock divorce mediation. So that will be a very interesting one, and wait till you see the notice on that. And that will then conclude this season of webinars, and we'll be picking up again in September. So thank you very much. It was really excellent, and I hope everyone enjoyed it.
I hope so too.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Okay, have a great day.
You
Okay,
Bye-bye.
bye-bye.